Hello, my name is Debbie Reynolds. They call me the Data Diva. Today I want to talk about data privacy and a recent case where Meta was found by a jury to have invaded the privacy of users of the Flow Reproductive Health app. So a jury actually said that Meta, who's the only company left in this case, that they have violated the privacy rights of users. And so the laws that they said they ran afoul of were the California Invasion of Privacy Act and the Confidentiality of Medical Information Act in California. This particular case is a big deal. This is another one that I call HIPAA-adjacent, HIPAA-adjacent data. So the data from these reproductive health apps, they're sensitive in a couple of ways. One is that it's very personal information about someone's health and well-being, even though it may not be covered federally under our U.S. HIPAA law. These are things that, for example, if someone's location is being captured in this information, that location data may be considered sensitive data in some ways. I think it's really interesting that they used these two laws in California because they aren't, again, they're not HIPAA, quote unquote, related, but they are, California laws. And then also, I think we're just seeing an evolving space around the use of these particular laws as they relate to collecting data that's now considered sensitive. So before, like many years before, it may not have been a big deal if companies felt like that they were collecting data about someone, especially if it was health related, if it was not related to HIPAA. But now there are so many other laws that they need to be concerned about, especially because the way that the technology is being created and implemented is able to do things that were not able to be done before. So the way that companies, especially using marketing, if they're targeting people, they're collecting information that's of a sensitive nature. We've seen this in other cases where, like, maybe something around someone's sexual orientation was captured without maybe a company realizing that that data that they were collecting they maybe should not have collected, or maybe that the data they were collecting should have been handled in a different way. So this will be something to watch because I think that as more companies do advertising, as more companies create these apps that are not really covered under traditional US health patient provider laws, we're going to see a lot more cases. And so for businesses, I think the message is, really go over what you're doing in marketing, really go over what you're thinking about implementing and rolling out, especially if you're touching on some of these data categories that maybe you didn't previously think was considered to be sensitive data because it really fell out of maybe your mindset about maybe HIPAA data. So I think of it as more regulated data, so regulated in different locations by different states. But if you're dealing with anything dealing with someone's health, maybe their sexual orientation, even if it's not covered by any federal law, you still need to watch out for the state laws, and then also being careful about how that data is not only collected, how it's retained, and what the data life cycle is for that information going forward. And I think the biggest issue here that a lot of people have is that they didn't really understand or know how this data is being collected and why it was being collected and how it's being used. So that transparency is really key in these types of things. So for me, it's all about minimization of data and then also making sure that that communication is really there. So it's going to be interesting to see how this case plays out. It will be interesting to see maybe other companies how they react to this case. It's a really big issue. That's it. Thank you.